Good morning, everybody. My name is Mariana Mitchum. I am with the ATF. We are going to get started with this training in about 5 minutes, so please just sit tight. The training will kick off at 10 a.m. Eastern. There will not be the ability for audience members to verbally ask questions just because of the size of the training. We don't want everybody talking over each other. So if you have any questions, you can certainly type them in the chat or the Q&A. I would encourage you to hold your questions until we get through the PowerPoint. The PowerPoint will take about 20 minutes because I think a few of your questions will be answered there. But again, you are welcome to use that Q&A to submit any questions you have. Again, we'll get started at 10 a.m. Eastern. Thank you. Good morning, everybody. My name is Mariana Mitchum. I'm with the ATF. We are going to go ahead and kick off this virtual training. A couple quick things. I've already seen people posting comments and questions in the chat. That's great. Please keep doing that. This PowerPoint, it is available on our website. If you go to atf.gov, you can simply go to the search bar and type in stabilizing braces. It will bring you to a page dedicated to information about this rule. You will have this exact PowerPoint on there, as well as a list of FAQs. There have been several questions about whether or not this audio is being recorded and whether or not it will be posted. It is not being recorded. We are looking into possibly creating another video like we did for the frame or receiver final rule. But if we are able to do that, we will certainly post it on our website. But again, all this information is available on the website. At the end of the PowerPoint presentation, we will also show the link to get there. But again, you can simply just go to atf.gov and type in stabilizing braces. There is not the ability for the participants to verbally ask questions. We have nearly 1,000 people in this training right now, so obviously that wouldn't work with everyone talking at the same time. So if you have any questions, please use the chat or the Q&A and you can type your question in there. The PowerPoint will take us about 20 minutes to get through. I do encourage you to hold your questions until we get through that PowerPoint because I think many of them will be answered for you, but you are certainly more than welcome to begin asking questions. All right, let's go ahead and get started.
Okay, so we're going to get started with the background and how we got started or how we got to where we are today. So in November 8, 2012, an FFL submitted the first stabilizing brace prototype to ATF, which was a brace that attaches to a heavy AR-type pistol. The brace would rest on the forearm and could be fastened with a strap. According to the submitter, the purpose of the brace at the time was to provide security for disabled shooters or anyone who did not have the physical strength to accurately shoot a heavy pistol. The submission was to get a determination as to whether the device, when attached to a pistol, would change the firearm classification from pistol to something else under federal law. Based on the information provided, ATF inspected the brace device and found that that particular prototype, when attached to a firearm, did not result in a firearm designed or intended to be fired from the shoulder. Well, since that time, the firearms industry has been flooded with so-called stabilizing braces that no longer resemble the original prototype, and most of them have been marketed and sold as shouldering devices when attached to a pistol. That was just a brief synopsis of the background, but you can go to the final rules preamble, section 2B, to get the entire background. So here's some photos of the original prototype, which is also posted in the final rule on page 6483. And as you can see, it's attached to it's attached with the strap, and it's rested on the forearm. Okay, so summary of change. The final rule's amended definition of the term rifle now provides that a weapon equipped with an accessory, component, or other rearward attachment, meaning stabilizing brace, giving surface area for shouldering the weapon, will generally meet the definition of a rifle. There are other relevant factors that in the final rule that must be considered. The intent of the final rule is to clarify that firearms with attachments that provide surface area for shouldering indicate that it is indeed designed, made, and intended to be fired from the shoulder. So the effective date of the final rule. The final rule was signed by the Attorney General on January 13th of 2023. It was published in the Federal Register yesterday, January 31st of 2023, which starts the 120-day countdown for all compliance obligations set out in the final rule. The deadline to comply with the final rule's statutory requirements is May 31st, 2023. Implications on classifications. So what are the implications of the final rule and its amended definition of rifle now that it includes stabilizing braces? Well, this means that all previous classifications are superseded and considered null and void moving forward. Firearms with such attachments may be submitted to ATF for reclassification, which we'll get into later in the presentation. There are other alternatives available for anyone who does not wish to go through the NFA registration process, and we'll also get into that as we continue in this PowerPoint.
Moving into the regulatory definition of rifle, which can be found in both 27 CFR 478.11 and 27 CFR 479.11, which both define the term rifle as, one, for the purpose of this definition, the term designed or redesigned, made or remade, and intended to be fired from the shoulder shall include a weapon that is equipped with an accessory, component, or other rearward attachment, e.g. a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder, provided other factors, as described in paragraph 2, indicate the weapon is designed, made, and intended to be fired from the shoulder. When a weapon provides surface area that allows the weapon to be fired from the shoulder, the following factors shall also be considered in determining whether the weapon is designed, made, and intended to be fired from the shoulder. 1, whether the weapon has a weight or length consistent with the weight or length of similar design rifles. 2, whether the weapon has a length of pull measured from the center of the trigger to the center of the shoulder stock or other rearward accessory, component, or attachment, including an adjustable or telescoping attachment with the ability to lock into various positions along a buffer tube, receiver extension, or other attachment method that is consistent with similar design rifles. Continuing into 3, whether the weapon is equipped with sights or scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed. 4, whether the surface area that allows the weapon to be fired from the shoulder is created by a buffer tube, receiver extension, or any other accessory component or other rearward attachment that is necessary for the cycle of operations. 5, the manufacturer's direct and indirect marketing and promotional material indicating the intended use of the weapon. And lastly, 6, information demonstrating the likely use of the weapon in the general community. Shown here, to meet the criteria 1, you have to have sufficient surface area that allows the firearm to be shoulder fired. Here's provided examples. And if surface area is provided, we're going to get into 2. When a weapon provides surface area that allows the weapon to be fired from the shoulder, the following factors shall also be considered in determining whether the weapon is designed, made, and intended to be fired from the shoulder. Weight or length. If the weight or length of the firearm is consistent with the weight or length of similar design rifles, then this would be an indicator that shoulder firing the weapon provides stabilization and is beneficial in firing the weapon, and thus that the firearm is designed and intended to be used in this way. We're given examples here showing that we're going to compare apples to apples. This is going to be an AR type to an exact AR type. Doing that with the weight or length, it will also be done with the length of pull, which we'll talk about later on. But this here is showing an AR type with a stabilizing brace or arm brace at the top and a manufactured shoulder stock commercially available in the bottom. Same thing here, showing that apples to apples comparison with the braced firearms at the top and the manufactured commercial stocks on the bottom photos. Length of pull. Length of pull is a common measurement of firearms. It describes the distance between the trigger and the center of the shoulder stock. Shoulder fire weapon generally will have a length of pull that allows the placement of the firearm shouldering device against the shooter's shoulder, while also ergonomically allowing the shooter to engage the firearm's trigger. Adjustable or telescoping attachments that lock into place provide horizontal support for firing from the shoulder. This is showing the example of the proper way to take that measurement from the center of the shoulder stock to the center of the trigger. Sights or scopes. Sights or scopes that cannot be used with shouldering the weapon indicate the firearm is designed and intended to be fired from the shoulder. Here providing an example showing that eye relief to where in order for that sight or scope to be used properly, the eye relief would have to be brought up to where it would be fired from the shoulder. Continuing with further examples of rifle type scope at the top. The second photo in the middle is showing your red dot type sight or optic. However, that is also shown with the magnifier. In order for that magnifier to be used properly, it would have to have that correct eye relief. So shouldering the weapon would be one of the key factors. And the bottom picture, again, being a thermal sight or scope, which you would need that same eye relief, bringing the firearm to be fired from the shoulder to obtain the proper eye relief. Rearward attachment. An AR pistol with a standard 6 to 6.5 inch buffer tube may not be designed and intended to be fired from the shoulder, even if the buffer tube provides surface area that allows the firearm to be shoulder fired, because it is required for the cycle of operations of the weapon. What we're stating there is understanding that buffer tube may provide surface area. However, we also understand that that buffer tube is needed for the cycle of operations for the firearm to function as designed and intended. Here's a cutaway showing that with a stock on the rear. However, that cutaway is showing the buffer tube, which contains the buffer and buffer spring needed for the cycle of operation. Here's examples of rearward attachments on firearms where you do not need that rearward attachment for the firearm to cycle and operate as designed and intended. Marketing and intended use. A manufacturer's marketing and promotional material for a weapon are relevant in considering the likely use of the firearm in the general community. And lastly, the use of the weapon, information demonstrating the likely use of the weapon in the general community.
The affected parties of the final rule. The affected parties are unlicensed possessors. Those are individuals that currently possess these. We have firearms, federal firearms licensees who are not qualified as manufacturers or importers under the NFA. We have our FFLs that are qualified as manufacturers or importers under the NFA, and we have our government entities. The department is foregoing the tax, so persons in current possession of firearms equipped with stabilizing braces are not required to pay the tax. If you're an individual FFL or FFL SOT dealer, you will be required as of yesterday, and you have until May 31st, 120 days to complete an E-Form 1, and you will not be required to pay the making tax. If you are an FFL importer or manufacturer under the NFA, you have the 120 days up until May 31st to submit an E-Form 2 for any of these firearms equipped with stabilizing braces that you have in inventory. Because the E-Form 2 is not a tax paid form, it is a notification. There was no tax forbearance there. And once these firearms are registered, all applicable transfers are subject to the tax payment. Again, options available for possessors, individuals, actually options available for possessors, I'm sorry about that. You have the option to remove the short barrel and replace it with a 16-inch barrel, but we have to consider that it needs to be 26 inches overall to be considered a rifle under the GCA. They can permanently remove or dispose of or alter the brace so that it cannot be reattached. They can turn it into their local ATF office. They can destroy the firearm, or you can register it as set forth in the following slides. Non-licensees, again, these are our individuals that currently possess these items, and it is a pistol with a stabilizing brace currently in possession as of yesterday. They will be able to submit the E-Form 1 prior to May 31st, 2023. They will not be required to pay the $200 making tax. They are able to adopt the markings that are currently on the firearm. They will not be required to mark it unless it does not have any markings on it. And at that time, they would need to comply with 478.92 or 479-102. Our FFLs that are not qualified as importers or manufacturers under the NFA also have those same options. You have the option for anything you currently have in inventory, firearm with a stabilizing brace, 120 days up to May 31st, 2023 to submit the E-Form 1. There will not be a making tax of $200. You may adopt the markings on the firearms. Unless the firearms are not marked, then you would be required to comply with 478.92 and 479.102. FFL importers and manufacturers under the NFA. If these are for FFLs that are not importers or manufacturers under the NFA. If you want to continue to engage in the business of dealing in SBRs that are equipped with the arm brace, you would need to pay the special occupational tax under the NFA to become a dealer. And if you were to want to continue to manufacture SBRs with stabilizing braces, you would be required to pay the manufacturing tax under the NFA to become a manufacturer of NFA firearms. Next slide. FFLs who are qualified as importers and manufacturers under the NFA, that is the E-Form 2 for anything you currently have in inventory that has a stabilizing brace on it or with it. You have until May 31st, 2023, and any future transfers, once registered in the NFRTR, are subject to the proper paperwork of Form 3 to an FFLSOT or Form 4 tax paid transfer. Government entities who have these in their current possession, they can E-Form 10 those devices, but they are limited to future transfers. They can only go to other government entities. They can currently also do the E-Form 1, which will be tax exempt for anything that they currently have in inventory. They will also have until May 31st, 2023, and there will not be a tax payment for that. Transfers after January 31st, 2023, any SBR must be registered in the NFRTR before it can be transferred further. And if it's going to an individual, it would be a tax paid Form 4 transfer. Any stabilizing brace that is made after yesterday's date, so anybody that makes one today that currently doesn't have one in their possession would be required to complete the NFA Form 1, and they would be required to pay the making tax. These are our resources. You can go to the first link and you will find the PowerPoint, the Q&As, how we got to where we are. We have our E-regs. We have the E-Form address if you need to get to the E-Form system. And then if you need to become a NFA dealer and pay the tax, that is the fourth link down. FIPB will take your questions, so you can email us at fipb@atf.gov. If you have technical questions regarding does something qualify, you will send those to fire_tech@atf.gov. If you have questions about rulemaking processes, those would go to ORA@atf.gov. And if you have questions regarding the E-Forms process, you can go to NFA Ask the Experts.
Okay, we're going to go ahead and jump into some of your questions. Again, it looks like so far we've gotten a lot of similar questions, so we may not read your exact question verbatim if we've already addressed it in a previous question. All right, the first question we have, quick question on documentation required to prove that a disabled person qualifies to still use the stabilizing brace on their pistol without being an SBR. This is a common question I received from disabled combat veterans and those who have suffered a stroke, who will still want to be able to shoot their legally purchased AR pistol with equipped brace.
So there is no exception under the National Firearms Act for possession of an unregistered NFA firearm because of a disability. I think that there was some confusing information put out there. I read some news articles where it was confusing, indicating that you could possess it if you used it because of a disability. That is not accurate. The way the rule reads is that if you have an arm brace that does not qualify your firearm as a short-barreled rifle and you use it because of your disability, then that's not affected by it. And we're talking about those that were originally designed where there were small pieces of rubber that extended for the mere purpose of wrapping around your wrist. That's what those were referring to. So if you have an NFA, if you have a firearm that qualifies as a short-barreled rifle, it must be registered. Now, again, you can do it for the next 120 days tax exempt. You do not have to pay the $200 tax. So, but you would have to register that firearm. So even if you're disabled and use it because of your disability, you would not be able to possess an unregistered NFA firearm.
Okay, next question. And I think there's been a lot of confusion about this so-called 88-day NFA check. So the question reads, what happens if you aren't approved in the 88 days and it becomes a denial? What happens next?
So that information is not accurate. The 88 days is a research period for the FBI. We do not know how long it's going to take to process the applications outside of the 120-day window, depending upon how many applications that we receive. The information regarding the 88 days out on the blogs is not accurate information being provided.
Okay, let's talk about the 120 days. If the Form 1 or Form 2 is not processed within that 120 days, but it is submitted by the possessor by May 31st, are they okay? Are they in compliance?
They are okay. They just need to have a copy of their submission through e-forms as proof of their submitted registration.
So as long as they have submitted either the Form 1 or the Form 2, depending on how they are, what class they fall into, whether they're an FFL without an SOT or they're an FFL that has a manufacturer importer SOT, they submit the form, they have documentation that they submitted that form, they are in compliance. It doesn't have to actually be approved within that 120 days, correct?
Yes.
Thank you. Okay, next question. Can the buffer tube on an AR pistol have notches and not be considered an SBR?
Yes, the buffer tube, even if it has a multi-position buffer tube or a pistol buffer tube, we're saying that the buffer tube is okay. We understand that it is needed for the cycle of operations. It would be any attachment to that we're looking at as far as does it provide surface area to be shoulder fired.
Okay, next question. If a firearm was already shipped before the rule was published and it has a brace, when the buyer comes to pick it up, do we just remove the brace and do the transfer, or can we not do the transfer?
So your options are there. You certainly can't transfer it with the arm brace attached because you'd be transferring it if a firearm is unregistered. So then you look at your list of options, one of which, of course, is to remove the arm brace and do the transfer. That's the easiest and quickest way to do it, clearly, because you can pop it off in a matter of seconds. If you choose to leave it in that configuration, then you would have to register it on a Form 1, but that means that you possessed it before the effective date. If it is still in transit and you receive it after yesterday, if you receive it today, for example, you would not be able to receive it because that's an unlawful transfer of a National Firearms Act firearm that's unregistered, and you would not be able to register it either.
So to the very next question, if there is a firearm in transit and it is a pistol with an attached stabilizing brace that now qualifies as an SBR, it's in transit and the FFL receives it today. The rule was effective yesterday. They receive it today. What are their options? Should they refuse delivery?
So first of all, you should refuse delivery, and it should just be returned to sender. It should still be in the possession of whatever shipper is doing it, and they should return it to the person who sent it. The second option, of course, is if you open it and you find yourself with it, now you've received an unregistered NFA firearm, you would handle it the exact same way that if someone mails you a machine gun that's unregistered or a silencer that's unregistered. And those options, of course, are calling law enforcement, calling your local ATF office, working through that. Those are typically what's done.
Okay. The next question is going to deal with state laws, and there are a bunch of questions we've gotten about different state laws. So we'll handle this sort of in general, discussing state laws. What happens within states that already have an SBR ban? Are those individuals now breaking their state-specific laws, and what can FFLs inform them to do in regards to their state?
Okay, as a general answer, we are not going to comment, and we cannot comment on individual states' laws. You're going to need to reach out. I think typically you reach out to the Attorney General for the state if your state has a specific law enforcement, state police, or something that handles firearms. You're going to reach out to them and ask them specifically how to be in compliance with their laws. Now, if for people who attempt to register a firearm, to file their E-Form 1 and they attempt to register this, ATF, of course, does the research and realizes that a particular state does not allow for that, we will not be able to approve that E-Form because we can't approve an application when it puts the person who submitted it in violation of state law. So we won't be able to approve it in those states that have banned SBRs.
Okay, thank you. The next question, there are several questions related to importation. There seems to have been some confusion regarding imported pistols to which stabilizing braces were later added. Recent changes made to the ATF FAQ document seem to have now clarified the issue. Can we conclude that the answer to FAQ 9 related to imported pistols that were subsequently equipped with stabilizing braces is the correct and final position of ATF on this matter? So there's a lot of questions about imported pistols that were then equipped with a stabilizing brace.
So everyone knows that this is the 922R, and that's what we're talking about here. You are going to be able to register those firearms. The possession of those firearms is not unlawful under 922R. It's the making itself. The possession is not unlawful, and we will accept registration on it. You don't have to swap out parts. You don't have to get under 10. You can just go ahead and register those firearms, but you will not be able to make them subsequently after the effective date of the rule.
So for those people that had those items in their possession as of the effective date of the rule, which was yesterday, can register them,
yes,
correct?
You can register them. You can remove the arm brace. The exact same options are available to you that are available to everyone else.
Thank you. All right, next question. What are you considering sufficient surface area to be fired from the shoulder?
Sufficient surface area is anything that allows it to be fired from the shoulder. And I know the next subsequent question is, well, what about our AR type pistols, which we've already covered? The AR type pistol has the buffer tube, which is necessary for the cycle of operation, although it allows for the firearm to be shouldered and provides enough surface area for that to be shouldered, it would not be included. So it's any surface area that would allow for the firearm to be shouldered.
And we've gotten a few questions about the presentation, the slides that is posted on our website. Again, just go to atf.gov. You can simply type in stabilizing braces in the search bar, or there's a link that we're going to show you here at the end that you can copy that down as well. All right, next question. So will the old school padded pistol buffer tube make it still be considered a pistol since it doesn't give surface area like in your examples?
Yes.
Okay, next question. Is there a requirement for SOT holders to engrave their info after filing a Form 2, or will they be allowed to adopt markings as well? That you guys.
What was the question, Mariana?
Is there a requirement for SOT holders to engrave their info after filing a Form 2, or will they be allowed to adopt markings as well?
They are allowed to adopt the markings.
So everybody, whether you're filing a Form 1 or you're filing a Form 2, if your firearm is already properly marked, so it has the manufacturer's name, the model, the caliber, if there is one, the serial number, you can adopt all of that and submit the form with those markings. You do not need to add any markings yourself.
Correct.
Okay, next question. The Prisma skeleton fin type brace has 2 screws that separate the fin from the buffer tube sleeve. Can I just remove the fin and leave the sleeve on the buffer tube?
Some of the braces are designed like that, where you could remove the fin and have a sleeve. However, that sleeve may be adjustable to extend what would be length of pull and the rearward surface. Remember, it says accessory component or other rearward attachment that provides shouldering area. So if you left the sleeve on there, you would risk the fact that you added surface area further back than the standard AR pistol buffer tube, which would not necessarily make it a rifle, but would then trigger the holistic approach to evaluating the firearm as a whole, taking in all the factors listed.
Okay, next question. Can a TAC-14 or Shockwave with a brace be registered for free as an SBS?
So the answer to that is no. This regulation amends the definition of rifle. It doesn't talk about short-barreled shotguns. It doesn't define shotgun, only rifle. We've made it clear in the rule itself, though, that any classification that occurred prior to the effective date of this rule is invalid, and that includes any classification where a pistol brace was added to a pistol grip firearm. So those would be evaluated to determine whether or not they're short-barreled shotguns. As we explained in the final rule, those were never intended to be fired with one hand, so therefore the addition of the brace was not necessary so that you could fire it as a pistol. Rather, it was essentially added so that you could provide surface area to shoulder it as a short-barreled shotgun. Any classification that's out there that was written prior to that, though, has been rescinded.
Okay, next question. Once an individual registers their SBR, do they have to keep the brace attached, or can a stock be added once the stamp is approved?
Once the stamp's approved, you can add whatever stock you'd like to it. Again, we're showing this as it's intended to be fired from the shoulder. So a shouldering device is a shouldering device to keep that within that purview. So you can add whatever stock you'd want to. It's still providing surface area. It still would be an SBR.
Okay. When you say remove the brace to be in compliance, do you mean just take the brace off, or do you mean swap buffer tube that can no longer accept a brace or stock?
So the brace can be removed and something like a mil-spec adjustable buffer tube can stay on. The only concern there would be constructive possession, where you'd want to treat that brace like any other shoulder stock, and you would not want to have it stored right next to a firearm that you had just removed it from.
Okay, next question. Can a shoulder strap be attached to a pistol buffer tube or lower receiver, swung around the shoulder and extended forward to stabilize the pistol?
Yes, that's always been allowed, like the old MP5Ks, where you basically use your sling to punch out the weapon for stability.
Okay, next question. You say the weight length of the firearm is a factor for determining whether the gun is considered to be fired from the shoulder. Can you please give us an example of a gun that has a brace and the length and weight is acceptable to not be an SBR?
Again, I touched on this yesterday, where there are some braces out there that really do not provide rear surface area. Unfortunately, most of them have not went to the market simply because of that factor. They didn't really have a secondary use to provide it as a shouldering thing. So there are some out there. We're not really seeing them marketed currently.
How does the final rule apply to assembled complete lower receivers, no barreled upper attached or in the box, that have a factory installed brace? They are sold and marketed as a pistol lower by the manufacturer, with pistol written on the packaging but not engraved on the lower themselves. Does the final rule change the way they are transferred?
So they should be they're being transferred as receivers because they haven't been built out. Under the rule, you would not be able to register it during the 120-day period tax exempt. What you would do is, if you intended to build out with a barrel less than 16 inches, you would file a standard Form 1, an E-Form 1 hopefully, and you would pay the $200 tax. And after you receive your tax stamp, then you could build that firearm. But as they're being sold with no attached, no upper to them, those are receivers. That's the way they're being sold, or should be sold.
So we have several questions on this. So again, just to be clear, if it is not a completed firearm, it does not fall under this final rule.
That's correct. You cannot register if you have a receiver that you intend to build out with an arm brace and a barrel less than 16 inches. Under this rule, you can't do it. This is for bearing the tax, the $200 tax on currently possessed firearms with a barrel of less than 16 inches that have a arm brace that qualify the entire weapon as a short-barreled rifle.
And when we say currently in possession, we meant as of the effective date yesterday, January 31st.
Yeah, exactly.
Nothing, no newly made items.
No newly made items as of yesterday.
Okay, next question. How does the ATF have the authority to waive a tax that is ordered by Congress? And if they are found to not have said authority, will they be covering all of the taxes to be collected?
ATF has the authority through the Internal Revenue Code, Section 7805, to enforce waived taxes, and that's covered in the rule extensively.
Thank you. Okay, next question. If a firearm purchased online comes into our shop for transfer with a brace between now and May 31st, do we transfer said firearm? So if somebody brings one of these firearms into your store, they cannot transfer it to you in that configuration because that's an SVR unless that firearm has been registered. So that would even get past applying for it, it would have had to have been processed and registered to that individual. At that time, it would be an NFA transfer. So it would have to follow all of the NFA regulations to complete that transfer. Now, if the person has not registered it, they cannot transfer it to anybody in that configuration because it would be the transfer of an unregistered NFA item. So their options to transfer it to you would be to remove the brace or to add a 16-inch rifle barrel. Okay, next question. Do you plan on slowing the current processing rate of Form 4s in an effort to expedite these amnesty submissions? If so, what lead times can we expect on e-Form 4s?
No.
I would also be clear that this is not an amnesty. This is a waiver of our this is tax forbearance under 7805.
Our paper form, so a paper form 1, paper form 2, are those allowed to be submitted for these items?
Yes, but preferably e-forms is the route that needs to be taken.
And submitting it via e-forms will likely lead to a quicker processing time, correct? Okay, next question. At what point is an FFL dealer allowed to sell an arm brace to a customer who has previously purchased a pistol?
So what we're talking about here is the concept of constructive possession, or maybe a structured transfer of an NFA item. We don't want to go into the specific facts of that because an analysis of whether or not something is constructive possession is extremely fact driven. Generally, what the law says is that if you transfer an item, for instance, you break it down, you pull the arm brace off and you hand them both pieces, with the AR pistol along with the arm brace, you are transferring a short-barreled rifle. However, if you sell barrels and receivers and stocks and arm braces, and you have those on your shelves, you're not necessarily in possession of short-barreled rifles because you haven't configured that way, and there are legal alternatives to constructing a short-barreled rifle. Those are the extremes. So, but we don't want to go into specifically whether or not someone's precise actions are going to be considered a constructive transfer of a short-barreled rifle. Typically, what ATF would advise is that you do not transfer the same items to a customer, certainly not at the same time, but also if you know that the customer is going to assemble a short-barreled rifle that's unregistered. Whether or not there's a duty to ask is something you need to consult an attorney about and get legal advice on your specific questions regarding the actions that you are contemplating taking.
Okay, next question. There is an estimated 40 million braces on firearms that consumers own. If 50% of those consumers file Form 1s within the 120-day grace period, this would mean 150K submissions per day for the 120-day grace period. Can you please advise what preparations the ATF has made to e-forms to handle this significant increase in daily submissions so that approval times don't extend indefinitely for everyone in the e-form system?
Sorry, before we get to the actual processing part of it, I just want to address that 40 million number. That was an estimate put out during the whole rulemaking process by the Congressional Research Service, which is a great nonpartisan research agency. But at the same time, there was no underlying methodology about how that number was discussed. So it's just a number that's out there. And our rulemaking does discuss why that number was not suitable for our purposes and why, for purposes of the rulemaking, we went with other estimates. So just wanted to say there's not like a definite 40 million number out there.
To address the e-form 1s influx, we will be using additional resources to process those applications outside of the regular workflow of the e-form 4s.
And then we've created a split flow for the people who are complying with the ruling. They have a separate link that they use in the e-forms, and then that is separate from the people who normally do business in NFA items. So the two of them should not interact in the processing.
Okay. Next question. What should FFLs do with the braces once they are removed from existing inventory? So the braces by themselves, not attached or associated with a pistol, are what?
They're nothing more than accessories or parts for a firearm. They're different than you would have any other stock within the business. It's the same thing. It can be treated the same thing. We're not going to be regulating those parts or accessories. We're regulating the firearms themselves as a whole.
Does this apply to pistol caliber carbines, CZ, Scorpion, Ruger, PCC, etc.?
Yes, most of those PCC type firearms have some version or have a brace that's designed to attach to them. Any of those would fall under the purview of the final rule it would affect.
I was proactive in SBRing a stabilized pistol. I think the individual is saying registering their pistol with a stabilizing brace as an SBR. Did not realize I would have saved $200 if I procrastinated. Can I get a refund?
Yes, if just released, I think it was last week, we have an option on the e-form system. If you go to your, the application that's still in process, there's a little icon there that you can select to withdraw the form, and it will send us a letter that says you're withdrawing it.
Does that apply to if it's already been processed and approved, or it's just in process?
It's just in process.
So if it's already been approved, there's no refund.
Yeah, because you've already made it.
Yes, and to be clear, the tax forbearance would only apply from yesterday when it was approved to May 31st. That's it. That's that time period. So anything before, unfortunately, when it's submitted between that time, that's the only tax forbearance when it's submitted during that time.
Okay. I am an 07, but do not have an SOT. Is it considered manufacturing to change from a pistol to a rifle? Not under this final rule for this specific circumstance. So those options to register it or to add the 16-inch rifle barrel, we are allowing that. There is nothing else that you would need to do as far as getting a different type of license. The next part of that question is, would this be subject to the excise tax and filed on my AFMA report? That's an excellent question and one we got yesterday, and we are working on adding that question to our frequently asked questions. Okay, next question. How will this affect gunsmiths that may need to work on these firearms? So again, as we stated before, as of the effective date of this rule, which was yesterday, January 31st, these items, pistols with attached stabilizing braces, cannot be transferred in that configuration until they are registered. So current possessors, if they want to continue to possess them and or transfer them in that configuration, they have to first register them. Once they are registered, if somebody has a registered SBR, they can take it to a gunsmith for gunsmithing purposes, for gunsmithing work. To transfer it, to permanently transfer it to the gunsmith, they would have to follow the NFA procedures and transfer on an NFA form. All right, next question. What type of registry will FFL dealers and individuals have access to verify if a pistol is actually a registered SBR? There will be those that have registered a pistol with a stabilizing brace as an SBR, then realize the hassle will be to sell, trade, transfer. We'll simply remove the stabilizing brace so it appears to be a pistol. Since engraving is not required for these, there will be no identifying marks. Everyone will need to be able to access this very important info. So if the item is registered, the possessor of that item will have proof of registration, and you can request that from the individual. If an individual has registered the item and then decides to change that item so that it no longer falls under the SBR definition, they can simply notify the NFA to have it removed from the registry. Is there a specific process to have it removed?
They send in a letter saying that it's being removed.
Okay. And then lastly, if somebody brings a firearm into your store and you're not sure the legality of it, we encourage you to contact your local ATF office and they can work with you.
Also, if someone brings in an AR pistol to your shop and it doesn't have any type of shouldering device on it, then you would not be in possession of, while the firearm may have been registered in NFRTR, as long as it doesn't have the shouldering device attached to it, the configuration that you currently possess would be considered a pistol. It would not be considered a short-barreled rifle.
Okay, next question. Since the stock or brace is the offending accessory or part, should the brace have a serial number and be registered?
No, it's the firearm that gets registered, not the stabilizing brace.
What is the expected processing time for the tax forbearance Form 1s?
You don't
That
have
is unknown.
Again, just to be clear though, your requirement to be in compliance within the 120 days is simply submitting the form. It is not having it processed and approved. Next question, can ATF provide an example of a pistol equipped with a brace that would not be an SBR under the new rule?
Again, we have seen a few of these submissions. I think at least one of them was actually in the final rule that showed a stabilizing support device that did not have rear surface to be shouldered. However, on the market today, no, I'm not aware of any that are currently being marketed in that type of configuration.
Okay. Next question. This is on trusts, and we've had several questions on this. On your FAQ published, it says to register an item to a trust, it must be registered to a trust prior to January 31st. What info do you need to prove this?
Typically with a trust, you have all trusts require that you have a document that has the property that is controlled by the trust. It's usually called a Schedule A. That Schedule A will list your property on there. So it must show that the trust possessed the property prior to the effective date of the rule. What would not be permitted is for an individual to transfer it into the trust after the effective date of the rule and then have the trust attempt to register it tax exempt. What would need to happen for it to properly be property controlled by the trust is that the individual would need to register it and could do that during the 120-day period without paying the tax. And then after it is properly registered, can transfer it on a tax paid form, which is a Form 4, into the trust, and thereby having the trust control that item.
Okay, next question. How does an individual under the age of 21 comply? You can be under 21 and be gifted a braced pistol. Are you out of luck?
I'm not sure. I comply. So you're under 21. You have possession of a braced pistol. You can register it like anyone else within the 120 days, depending on state law. But
yeah, I think we're confused by the question itself. I don't know. Could you clarify what you're asking?
Yeah, so I'm sorry, whoever asked the question about under 21, if you could add a few more details, we'll try and answer that at the end. Okay, next question. A local university campus PD has 3 pistol braced firearms subject to the rule. How do they register? So let's just first talk about, before we talk about the police department and their duty weapons. If these are officers that have these as their personal weapons, they're treated just like everybody else. So the options under the non-licensed possessors, those are your same options as well. Now let's talk about the PD and their official duty.
So police department has 2 choices. They can register on a Form 10 or they can register on a Form 1. They could do either one. Either way, you wouldn't pay the tax. If you register on the Form 1, it allows the police department to later sell those. So that may be preferable. If they register on a Form 10, of course, then any subsequent transfer would have to be to other law enforcement. But those 2 options are available to all law enforcement agencies.
Okay, next question. How should we deal with firearms in our A&D books if they're logged in as pistols and then a 16-inch rifle barrel is attached and thus sold as a rifle?
Your A&D books would say that you received it as a pistol. You would log it out to yourself, log it back in as making it a rifle. So your acquisition shows it as a pistol. You would log it out to your FFL name. Again, log the acquisition again as your FFL name, and then you would change the configuration to a rifle.
Okay. Recommendation for pawn shops with active loans that have braces. We have added this question to the FAQs that are available on our website, but the final rule is now in effect as of yesterday. So it is the current possessor. Doesn't matter the reasons why you possess that item. So it doesn't matter that it's in pawn. You are the current possessor of it. Thus, you cannot transfer it back to the individual in its current configuration. You have those 5 options. So remove the brace, add a 16-inch rifle barrel. You can register it. Obviously, if you register it, then you would have to transfer it on a Form 4 back to the individual. But again, you cannot give it back to them in its current configuration because that would be considered the transfer of an unregistered NFA item. Next question, if a current non-SOT FFL manufacturer applies for an SOT, will the fee for the SOT registration be waived for the 90 days? No, it will not. But keep in mind, if you do not have an SOT as a dealer, you're just an FFL, any type of FFL, but you do not have an SOT dealer, you do not need the dealer SOT in order to sell these items after you've registered them. So you have to register them. If you choose that option, you register them. You can then subsequently transfer them on an NFA Form 4. You don't have to have a dealer SOT. It's only if you then further decide to go into that as a regular course of business, you have to get the dealer SOT. All right, next question. If we are transferring an item out of state, that dealer would receive the item after 1/31. Are we at this point unable to transfer them, or do we need to simply remove the brace? So again, the rule was effective yesterday, January 31st. You cannot transfer to anybody for any reason an unregistered SBR. At this point, you would have to either remove the brace, add the 16-inch barrel to transfer the firearm. So one of those two options, or like we said before, register it. The ATF FAQ for final rule states permanently remove or alter the stabilizing brace. The presentation states permanently remove and alter the stabilizing brace, which is correct.
So the language there is that you should not be in constructive possession of a short-barreled rifle. And you can do that by altering the buffer tube typically so that it can't accept a stock. You can do it by altering your arm brace such that it cannot be attached to your AR. You can divest yourself of it by throwing it away, destroying it, giving it to a friend, whatever you'd like to do. So there are multiple ways to be in compliance. The way these examples are given or the instructions are given is ordered for you to avoid a constructive possession by merely pulling the tube off and setting them side by side. With the argument that it's no longer a short-barreled rifle because the stock is sitting next to it, which would essentially be constructive possession of an SBR.
What happens if the Form 1 is denied? So that depends on the reason why the Form 1 is denied. If it is denied because you are a prohibited person and cannot possess a firearm, then you would obviously need to turn that firearm in or destroy the firearm. Otherwise, I would recommend that you contact either FIPB@atf.gov, or if it is a state issue, contact your state attorney general. After a stamp is approved, can you add a vertical foregrip?
Yes, vertical foregrip can go on to a rifle without changing its classification.
Next question, do I need to attach a photo to the application? If so, what do I need to include a picture of?
So it's not required that you attach a photo. However, we do recommend a close-up picture of the markings on the firearm. And it would be just in the application, you just upload a photo.
Okay. All right, next question. If I have a pistol chassis like a micro Roni, do I need to register the chassis with a pistol brace or the pistol that can be removed?
It would be the firearm itself. Again, it kind of goes back to us stating that we don't regulate accessories or parts. It would be the firearm, and it would be that particular firearm to that particular kit.
Okay. What do we do with conversion kits already in stock that are not attached to a pistol?
So the conversion kits, such as the Roni we just discussed, they are parts themselves and they're not regulated. They can be sold. The only concern would be the constructive possession of selling a pistol and a kit in the same purchase.
Okay. When submitting a Form 1, will the customer still only need to submit one set of fingerprint cards for multiple submissions in one envelope like it was before? Can multiple firearms be put on one E-Form 1?
No, for the E-Form 1, there's only one firearm per form on a Form 1 itself. Form 2, of course, you can have multiple firearms if you're submitting a Form 2. Regarding to the fingerprint cards, if you are not uploading the electronic fingerprint card submission, then you'll be provided with a cover sheet that indicates that they still need to be submitted. As long as you have all the cover sheets together and reference them to each other, you can submit the fingerprint cards and they will be accepted. But they have to be all in the same envelope.
Does the brace have to be removed while waiting for approval, or does the submission of the e-form cover this while waiting? So I think we covered that several times. Again, if you choose the option to register the firearm, as long as you submit your form within the 120 days, you're in compliance. How do I modify the firearm to comply to a new regulation that specifically said the brace cannot be reattached?
Again, you can divest yourself of the brace. That's one way for it to not be attached. We've already talked about the constructive possession. We should treat the brace like any other shouldering device and having it on hand. But other than that, we've stated again and again that you can simply remove the brace and divest yourself of it. You do not need to destroy it. It is a firearm part, and that is in compliance with the rule.
Next question. So anyone that submitted under the forbearance before yesterday will be denied.
So after we published on after we made it available on the 13th, after the Attorney General signed this, people began submitting these e-forms and checking the box saying that it was pursuant to the new regulation. Those are in the queue. They will be processed as part of this. So I think earlier well, legally accurate, I think we misstated what it was. We are accepting all of those submissions that occurred after the 13th of January, I believe, where the Attorney General signed the new regulation. Those are in the queue. Those are being processed. Those will not be denied. Those will not be rejected. They will be processed, I think, in the order that they come in. I don't know how NFA processes them.
Okay, just to be clear, a dealer can just remove all stabilizing brace on AR style pistols with barrel less than 16 inches and exposed buffer tubes. They can still be sold as pistols after the 120 days without registering it as a SBR, correct?
That is correct.
And they could be sold immediately as soon as they're in compliance, right? They can be sold. There's no 120-day waiting period to start selling them again. It's just once they're in compliance.
If you remove the offending feature and keep it as a pistol configuration, then you're selling it as a pistol, which is a non-NFA firearm.
Okay. If someone gets a disapproval from a clerical issue like a typo, are they now a prohibited possessor, or can they reapply?
No, you can reapply for a clerical issue.
Okay, can a person under the age of 21 register the firearm? I know with the new law in regards to individuals under 21, there is additional time and research done to approve, get it proceed. Will that delay the process further for those under 21 or prohibit some of them from possession? So I think they're mixing in two.
It's mixing in two things. So what ATF will do is on the Form 1, we would look to make sure it's compliant with state law, as well as do a background check to make sure you're not a prohibited person and comply with that part of the NICS background check process. So the under 21 applies when it's a transfer from an FFL. You are registering this as on an ATF Form 1 as the current possessor. You can register it as long as it's in compliance with state law and you're not a prohibited person, right?
All right, and then our last question. You mentioned additional resources for a large amount of forms due to come in. What are those additional resources, and where did the funding come from to add those resources?
The resources will be used within the Bureau, and it's not been identified which positions will be used to support those form processing.
It's all internal resources.
Correct.
Okay, that is all the questions we have. Again, we may not have read your specific question verbatim because we tried not to keep answering the same questions over and over again. But if you do not think that we answered your question, please submit it to us. If you have a technical question on a particular firearm, we encourage you to submit those to fire_tech@atf.gov. All other questions can be submitted to fipb@atf.gov. Again, this PowerPoint is available on our website as well as an extensive FAQ list. We are doing one more training. It is at 2 Eastern today. It will be the same link that you used for this training. You are more than welcome to join us for that as well. Thank you.